explain what is meant by judicial independence. In Britain, where there has traditionally been a fusion of powers between the executive, legislature and judiciary, it has been difficult to establish genuine judicial independence until the reforms made in the Constitutional Reform Act of 2005. Arguably before this act, the independence of the judiciary was more a matter of custom and practice than a matter of law, even though there has been little suggestion that the independence of the judiciary has been compromised. It hinged on such notions that no member of government would criticise a member of the judiciary, although having the power to appoint senior members of the judiciary, such as the Lord Chief Justice and Master of the Rolls, there would be no political interference in the process. Even Professor John Griffith, a severe critic of the judiciary as a political body, accepts that judicial appointments have not been politicised in Britain. In essence, since that date, the judiciary has become independent of the other two branches in significant ways. Government and Parliament as a whole accept the independence of the judiciary by not commenting upon any court case whilst running, although this independence is somewhat blurred when ministers often criticise the outcome of cases, such as the decision of Justice Collins to condemn the last Labour government over its detention of terror suspects at Belmarsh Prison. The reforms of 2005 made the senior judiciary independent from the legislature by ending the role of the law lords within the House of Lords, and they held their last case in July 2009. This underpins the principle of separation of powers, which is fundamental to such jurisdictions as the USA, but only became a reality in recent years in the UK. Consequently, a UK Supreme Court was established and sits in Middlesex Guildhall. The change in position of the Lord Chancellor, a senior member of Cabinet, currently Kenneth Clarke, was also to contribute to the new independence of the judiciary. This removed the blurring between the government and the judiciary over a key role formerly exercised by the Lord Chancellor, that of appointing judges. This role has been taken up by the Judicial Appointments Commission, which appoints judges entirely separate from any member of the government, and these judges serve until a mandatory retirement age of 70.